The torts question from July of 1998 is about as difficult a torts essay as you will find on any bar examination in the United States over the last 25 years. This is a hard question both because it contains many issues and because the analysis is hardly a slam dunk. Have a look with me at the call of the question. On what theory or theories, if any, can Paul recover damages from, and what defenses might be raised by Transco? Discuss. Diana? Discuss. So we know we're dealing with civil litigation. We know we've got one plaintiff who is pursuing two different defendants. We're going to have to come up with a theory or theories of liability, and we are focusing on damages. So we don't yet know whether this is torts or contracts or property or even corporations. But we've got a pretty good idea it's torts. And the reason is because one of the defendants is called Transco. And transportation companies feature prominently on torts questions. And the reason is it allows the examiners to test the common carrier standard of negligence. So we can guess that one of Paul's theories of liability, at least against Transco, is going to be for negligence. And as it turns out, Paul has many theories, and that's what makes this fact pattern so difficult. Another thing that makes this a hard problem is the facts themselves are quite problematic. Let's have a quick look together at the fact pattern itself. In paragraph 1, we learn about Transco, and right up front, they tell us Transco is a common carrier. You can pretty much put your pencil down at that point, down on your outline, and indicate that Transco is going to be sued for negligence. They wouldn't tell us Transco is a common carrier if negligence was not at issue. We find that Transco hauls toxic chemicals through an area where Paul operates a commercial greenhouse. So we know that we've got potentially ultra-hazardous materials, so strict liability may come to mind, and we know a little bit more about Paul. We also meet Diana in paragraph 1. Transco hires Diana as a consultant to assess the risk presented by Transco's activities. We learn in paragraph 1 that Diana concludes that there's little or no risk to nearby property owners if there is a toxic spill. And that's what she tells Transco. In paragraph 2, we find out about the predictable train crash. A train derails, the engineer has a heart attack while operating the engine, and we find out more facts about the operator. He's obese, and he had had a mild heart attack 5 years earlier. The derailment causes a chemical spill near Paul's property, and Paul closes his greenhouse business not because he has been hurt, but because he is afraid of being hurt when, in fact, no lasting damage resulted from the spill. In paragraph 3, Paul goes back to the greenhouse 6 months later and he resumes operations. But he's still frightened even though he's back in business, and he suffers anxiety and depression because of his fear. So our plaintiff apparently does actually suffer real harm. But it isn't the harm of being poisoned. It's the harm of fear. And now he comes to court as a plaintiff, suing Transco and Diana. Well, this is a fact pattern that establishes beyond really any doubt how important it is to outline. So please turn the page with me and let's have a brief look at the outline of issues that I generated to answer this question. With regard to Paul versus Transco, you'll see I come up with a laundry list of possible theories of liability. I put strict liability first. Strict liability is a stronger theory of liability than negligence, and the reason is a successful plaintiff doesn't have to establish fault on the part of the defendant. All the plaintiff has to do to establish strict liability is prove that the conduct occurred, not prove that the conduct was wrongful. So, with regard to strict liability, we will see on my outline, internally, I break it down first by talking about the ultra-hazardous activity, then causation, damages, and defenses, and I reach a conclusion. With regard to the negligence claim that Paul is going to bring against Transco, Here we do the same thing all first-year law students are trained to do. We consider duty, breach, causation, damages, and defenses, and then we reach a conclusion. But I don't stop there. Many applicants wrote about strict liability and negligence and then quit. But read on. Notice that I have a separate section hypothesizing liability potentially flowing against Transco for hiring Diana negligently. I also consider negligent infliction of emotional distress, although, to be honest, that might be a subset of negligence, and it certainly isn't an essential issue to consider to achieve a passing score on this fact pattern. I also consider nuisance, given that Transco's conduct has had the effect of interfering with Paul's use and enjoyment of his property. And finally, I conclude that Transco is going to be strictly liable for the injuries that Paul has suffered. Next, I consider Paul's lawsuit against Diana. I can see no other theory of liability aside from negligence, and I focus on duty, breach, causation, damages, and defenses, and I conclude that Diana is not going to be liable to Paul for negligence. I acknowledge that this is a somewhat close call, and reasonable parties might differ with regard to that conclusion. So here, even before we get to review my answer to this fact pattern, we see how important thinking carefully about the issues presented really is when we have to come up with an organized answer to this question. And I'm sure you're going to agree that going beyond a mere consideration of negligence and strict liability results in a substantially more thorough analysis of the relationship between these parties. So now let's have a look together, briefly, at the answer that I've presented. Right up front, as is so often the case, I lead with the facts. Right in the first very couple of lines, I indicate that Paul was damaged by the toxic spill from Transco's train, and he's got several different theories of liability. I start out by considering strict liability, and here I present about as stripped down a definition of strict liability as you can possibly imagine. In fact, for many of you, I bet you wouldn't even consider that this qualifies as a definition. Still, that's all I give you. I'm focusing my attention on the analysis. Notice, under ultra-hazardous activity, I'm focusing very carefully on the key fact. Rail transportation of toxic chemicals. That might be good enough to establish an ultra-hazardous activity right there. Then I focus on causation. Again, concentrating our attention on the ultra-hazardous nature of transporting toxic chemicals. And I point out that Transco itself was concerned about possible liability, and I point out that there were no factors outside of the control of the defendant that contributed to the accident itself. Damages is somewhat problematic in this case, and I focus a number of lines on damages. I look at the fact that Paul was emotionally upset rather than physically poisoned by this toxic spill. But, importantly, I point out that the reactions of this plaintiff are not unforeseeable, and they're also not unreasonable in the context of the facts that we are given. I consider that the best defense that Transco could present would be an argument that their transportation of chemicals is not so dangerous as to be ultra-hazardous. It seems to me, perhaps again reflecting my own bias as a defense lawyer, that it might be a close call. But even I conclude that Transco is liable to be found strictly liable for the injuries that Paul has suffered. And that's my conclusion. Next, I turn to negligence. And here I spend a fair amount of time both on duty and, more importantly, on causation. With regard to duty, I work in the law about how common carriers are held to a higher standard than others who transport individuals or property, and I focus on breach, finding a home for the facts about the engineer who is obese and has a history of heart trouble. Then I turn to causation. And to my way of thinking, causation is the most important and the most difficult issue with regard to establishing negligence on the part of Transco for Paul's injuries. It seems to me here important to focus on the zone of danger issue. and I find it to be a persuasive argument, and many candidates did not find it to be persuasive. But I do think it's important to raise the issue. And one other issue on the side of the defense that I raise is that under negligence, typically we do not award damages for quote-unquote pure economic harm. That is, economic harm that is suffered without some physical injury. And the reply of the plaintiff is that his emotional distress has a physical component, and that would be good enough to establish physical injuries. And I think that's not a bad argument, actually. I conclude that there is a lack of proximate cause. And I can tell you many candidates wrote passing answers that reached the exact opposite conclusion. Next, I consider negligent hiring of Diana. I think this is kind of a bonus issue, but as you read it and consider the few lines that I've written here, I imagine you'll agree that it is a colorable claim and one that certainly is not crazy to present. I focus very briefly on negligent infliction of emotional distress and nuisance. In the end, I conclude that Transco is strictly liable and will have to compensate the plaintiff based on that theory of liability. Next, I consider Paul's lawsuit against Diana for negligence, and I consider this to be by far a simpler case than his action against Transco. I focus on duty, breach, and causation. The analysis, I think all of you will agree, is very standard and not unreasonable. I hope you'll agree that my focus on the facts is both important and reasonably accurate. I conclude that Diana is not liable because I indicate that the plaintiff can't show that she breached a duty. And I also indicate that this plaintiff won't really be able to show that the conduct of this defendant is responsible for his damages. Here again, successful applicants did reach the opposite conclusion. And I present my answer, not because I'm trying to persuade you to agree with me, but because I am trying to help you sharpen your outlining skills, and because I want you to focus your attention on rigorous organization and careful and meticulous analysis of the facts.